So it's not that property at the end of King?
Yeah, it is.
Hi.
Yeah, so
Yes, sir.
I only got your comment of third party as it relates to
No, Tori, do you?
your situation. Let me just tell you, I saw it, it was well written.
Sure.
Well, no, I'm gonna take mine too. I was hoping you would come out. You forced me in and out.
You all bear with us just a minute. We're trying to organize a little bit of paperwork. So appreciate your patience.
Yep. And don't let me be involved. I'm not making any decisions. Tell me how much.
Long as pay for the line there.
Need to call to order this regular meeting of the City of Southport Board of Adjustment for July 22nd, 2025. Before we proceed with anything else, if you're able, please rise and join me in the allegiance. The pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, a couple of things on the agenda today, but before we proceed, we have a swearing in. You ready for it?
You administer the oath and you say swear to affirm after them. I, Jason Robbins, do solemnly swear that I will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina, not inconsistent therewith, and that I will faithfully discharge the duties of my office as a member of the Southport, North Carolina Board of Adjustment, so help me God.
I said swear.
All right, thank you.
Thank you.
Welcome back.
All right. Y'all all members,
You have before you the agenda. Before we begin the proceedings, we need to activate Mr. Dozier from his alternate position to serve as a full voting member today. Do I hear a motion to that effect? Second. Second. All in favor? Any opposed? Thank you. So Steve will be casting the vote today. As I said, you've got the agenda in front of you. You've got one item of new business. Any concerns or amendments about the agenda? Okay. So here a motion to accept the agenda as in front. Second. All in favor?
Aye.
Any opposed? You? For those in the audience who haven't been to Board of Adjustment meeting, and for, excuse me, for everybody who is on the board, this is our first time that we are live streamed on the city's, Facebook and YouTube channels. To be aware of that, the meeting is also being recorded, and that recording will be part of the public record. I think everybody heard, just in case, the microphones are here and here, and they should be good to pick up
Yes,
everything, including from the public.
yes, sir.
Thank you. Anybody have any questions about that before we go any further? So to talk about the process here, this is a quasi judicial hearing that we're about to have. It's a more formal type of hearing in which the deciding board, in this case, the Board of Adjustment, uses facts, evidence, and expert testimony to make a decision. It's more like a court hearing. Evidence must be substantial, competent, and material. Opinions, hearsay, and repetitive testimony will be ruled out of order by the chair. Should probably clarify, I'm Jason Robbins. I'm the vice chair of this board, filling in for the chair today, who's unavoidably out of town. Situations that require quasi judicial hearing include special use permits, variances, and appeals. On the agenda today is an appeal of a code of enforcement determination. In such cases of appeals, only actual official staff board determination or action can be appealed. The appeal must be made by a person with standing. The board may reverse or affirm the decision as a whole or in part. An example would be a resident appealing the denial of a permit for their property. How is a quasi judicial hearing conducted? Typically, the presentation of information will begin with city staff. Chair will swear the presenters in, either together one at a time. After staff presents their materials, the applicant and any representatives will provide testimony in favor of their request. Members of the public that wish to speak may do so, but the chair has the authority to ascertain whether they have standing and should be considered. After those who have opposed the request have spoken, the applicant has the opportunity for a rebuttal. The deciding board can ask questions throughout the hearing of evidence. After all evidence has been presented, the chair will close the comment period. The board can deliberate. After the deliberations, public hearing will be closed and the board will make its determination. After decision has been made, final order is composed that lists all the findings of facts and the conditions of approval. The final document will be signed by the applicant and the board chair and filed at the Register of Deeds office in Bolivia. And the applicant will receive the final signed copy. We do have a quorum for this meeting today. Anyone who plans or desires to make a statement as part of the proceeding will have to do so under oath. The question of standing often comes up in Board of Adjustment hearings. And the shortest definition that we found is this: standing is someone who has, or a person or organization who has standing and may appeal the decision. Standing typically refers to the owner of the property, the applicant for a permit, anyone who might suffer special damages as a result of the decision, neighborhood association that would be affected, or the unit of government that has made the decision being appealed. Proximity, financial investment, etc., do not establish standing. Standing must be ruled on by the chair and board only. In the case of expert testimony, architects, engineers, surveyors, appraisers, and other licensed land use professionals can provide evidence supporting their clients, but cannot make legal arguments or cross-examine evidence. Finally, in terms of conflict of interest, members of the board may be disqualified from participating in voting if any of the following conditions are present. If the board member has a fixed opinion prior to the hearing, the board member has an undisclosed ex parte communication, that's a discussion outside of the meeting with the parties to the hearing, that the board member has close family, business, or other relationships with an affected person, or that the board member has a financial interest in the outcome. If an objection is made and the member refuses to recuse him or herself, the remaining board members will vote on recusal. So that takes us to our next point. If any members know of any conflict of interest or the appearance of a conflict of interest concerning matters on the agenda, please so state at this time.
I just want to make public that I was on the Board of Aldermen from December of 2019 to December of 2023. Some of this took place in that time frame. Most of it heard that.
Do you feel like you
I
can,
don't think that impacts my ability to be part of it.
anyone have any questions or concerns? I need to make public that I was the listing broker for the property at issue at about 416 East Bay when it sold in 2018. I do not have financial relationships with the current owners, but I felt it necessary to disclose that for abundance of transparency. Do not feel like that impacts my ability to make a decision if my vote is necessary today. Anybody have any questions or concerns about that? All right. Probably. All right. Now the new business, are staff ready to present the city's position on the appeal of determination of the code enforcement officer on this matter? Swear you in. Is the Bible here for?
Yes.
Okay. Do you swear that the statement you shall make today to this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and position for the record, please.
I'm Maureen Meehan, and I am the planning service director for the city of Southport. Good evening, Chair Robbins and the board. This evening, staff is going to be reviewing case number AP 2502, which is the appeal of an administrative decision per section 27E of the Unified Development Ordinance. Specifically, this is going to be this is an appeal to the final notice of a zoning and code violation issued by myself and the code enforcement officer on April 3rd, 2025 for hardened structures within the city's right of way, including a fence and landscaping rocks. And this is on property located adjacent to 416 East Bay Street. And I would like to, for the record, prior to reviewing any of the property features itself, there is one correction I want to put into record for the staff report. On page 2 of 72 of your packet, the parcel acreage is 1.16 acres, not the 0.54 as written, and approximately 7,800 square feet, not the 23 acres. So just for context and to make sure that that was on the record. So
So the
7,800 approximately, yes. Thank you. So the subject property is approximately 7,800 square feet. It is zoned R10 and it is adjacent to the Cape Fear River. As stated, the property was purchased by the applicant in 2018 with an existing home on site without fencing or harbor structures in the right of way. The survey you were looking at is part of the deed that was recorded when the applicants purchased the property. And it shows the property itself with the home on it with no encroachments on the right of way at that time. After the purchase and prior to construction of the existing home between February and June 2019, the home was demolished and fencing and landscaping was installed. No fence permit on file for the installation of the fencing. So you'll see from the aerial photographs of February 2019, the original home is still standing on site. In June, the site is cleared. And then in 2021, you can see a very clear delineation of the cleared property with the fence and the landscaping installed. In February of 2023, a building permit was issued for the existing home that is standing now. The development director at the time had documented the violation of the encroachments within the right of way, but did not have any action or open a case on the issue. Then when the director left, the violation was then assigned to our code enforcement officer, who got photo evidence in October of 2023, as you can see there. As with all of our compliance issues, we try to go to the property owners prior to formally noticing a violation. So we tried to get in touch with the property owners to correct this violation for several months. There was no correspondence between the code enforcement officer or the property owners. Therefore, a formal notice of violation was then filed in January of 2024. Following that violation, the formal code enforcement procedure for the notice of a hearing and then the final order was followed by the code enforcement officer. Further, the code enforcement officer with the then city manager agreed to an extension with the property owners for the removal of the fencing and the landscapes to coincide with the certificate of occupancy that they were going to be receiving in several months. So they agreed that yes, if they were going to come into compliance, they wanted to wait until the certificate of occupancy for the protection of the construction happening on the site. So that on the screen, you will see the final as-built survey that was provided by the applicant in September of 2024 when the home was completed. You see the home built within the red lines is the property itself, and then there's a small building footprint due to the Camo 30-foot buffer. You also notice that there is a fence that is delineated on the survey that is encroaching within the right of way. And all the time while this is happening, the Board of Aldermen was holding discussions and considering changes and amendments to the encroachment and obstruction portions of the code of ordinances during this time. So I just want to kind of go through a timeline of the right-of-way ordinance changes that we're having. There was a public hearing for the obstruction and encroachment language for the city code of ordinances, and there was a amendment to section 16.8 and 16.10 on December 12th, 2024. And that is the current ordinance that we are using now that And all encroachments still must be removed. Vegetative encroachments are allowed to remain, and parking encroachments shall remain. And also provide some provisions for some new parking if certain standards are met. So that's in December. In the beginning of January, staff went out and we did identify all of the properties that had encroachments within the right of way. And we also put out a press release that the ordinance was updated and we were going to be passing out these courtesy notices. And at this time, it was a courtesy notice that the time the ordinance was adopted, there was a 6-month grace period that was afforded to those property owners that had encroachments. There is a caveat that all open code enforcement cases at the time would have to come into compliance without the grace period. So 460 East Bay Street was an open case violation at the time, so they were not granted the grace period. So staff then in January went through and we sent our courtesy letter at the end of January and doing public outreach for compliance. We wanted to work with all of the property owners as much as possible to bring everyone in. We identified approximately 85 properties that needed to come into compliance. And again, throughout the 6 months, we were working with all of those property owners, explaining what's process for a right-of-way permit, what is allowed, what's needed to be removed, so that they can be in compliance with the ordinance. In May, on May 13th, we sent a follow-up letter reminding property owners that hadn't come into compliance yet of the rules. And then again, it's still not a violation, but you still have 1 more month of the grace period to come into compliance. We would be willing to work with them if they needed extensions or how we can help them come into compliance any way possible. June 12th was the deadline for the grace period. That was 6 months after the adoption. So formal notices of violation were sent to 22 properties that had not come into compliance yet. So that's where we are. I wanted to give an idea so that I know there were some questions about the grace period and what happened. So that's where we are today. And staff would like to just state that, you know, the applicant's fence and landscaping are hard structures within the city's right of way and are not in compliance with the city's code of ordinances or the UDO. So they're in violation of section 16.8 and section 317D of the UDO. So we would ask that you will affirm our decision and request the removal of those structures. And that is my report.
Are there any questions from Ms. Meehan from the board?
Yes. So how many other encroachment removals have been started and or completed or open cases? Or
So about the 85, there's only 22 left that are outstanding. 63-ish.
Has the city ever removed the violations and split the cost to the owners?
We have not gotten to that point, no. We have not, in the past, no, we have not done it.
You're not doing it now.
We are not doing it now, but we do have provisions in the ordinance that we can go in and remove and visit the.
Well, I mean, this is notified where they should be already down, the fence should have already been gone.
Correct.
And you had all the right to go and remove it.
We did, but we were trying to work with the applicant,
All right.
with the property owners, yes.
Of the 63 or so that are off the list, what is do you have any disposition? Can you describe the disposition of those? Have they cured the encroachments? Have they reached other agreements with the city or?
Yes. So the ones that are in compliance have removed their encroachments from the property, or they have come in and received a permit that allowed them to have some of the uses that were originally identified, but then with some policy documentation with the Board of Aldermen and with the city manager, we were allowed to have a few other instances that were allowed to remain in the right of way itself for existing structures. But those are very specific, but everyone else has been coming into compliance, fully into compliance with removal, yes.
Other questions for Ms. Meehan right now? There are other presentations for the city's position on this? See Mr. Harmon here. Brady, do you have anything?
Yeah, I was just gonna go make a very brief forest housekeeping opening statement, and at the pleasure of the board, you know, I'll defer to the president council once, and the applicant wants to make a brief opening statement. Or otherwise we'll proceed through. We just have 2 witnesses for the call.
Go ahead.
So if you give me members of the board, Mr. Vice Chair, again, my name is Brady Herman. I'm here representing city staff's position in issuing the notice of violation for the fence encroachment for 416 East Bay Street. I guess more as a formality, even though pursuant to 160D 406C, it's already part of the record, but at this time, Mr. Vice Chair, I'd like to go ahead and enter in the staff report, as well as all the corresponding exhibits, as well as the applicant's appeal letter into the record.
Before you proceed, that's all part of the packet. Already?
Yes, and the affidavit was sent out this morning.
Yeah, and I'll let the applicant go enter in that into the record. I have no objection to that as well. But yeah, it's pages 137A2 of packet that you have.
Thank you.
Just want to remind the board, again, what the standard review you all have in terms of reviewing appeals of staff decision. You all step into the shoes of a code enforcement officer or Ms. Meehan being UDO administrator, and see to determine whether or not they heard in that decision. And it's the appellant or applicant burden of proof to show that an error was made. And I think here, the underlying facts are really not in dispute. The applicant property owner's fence is built and encroaches significantly in the East Bay Street right of way. It's approximately 99 feet in size. There are no facts to contest that. I think that's undisputed. And the UDO, as it was written prior to the December 12th amendments and after, notes about the violation. I will say too, that I do have a legal memorandum that I'd like to pass out to you all. Just some general premises of the law that I wanted to point to you guys as a board in order to be helpful in your decision making as it pertains to any arguments or defenses that opposing counsel or the applicants may make. So at this time, Mr. Chairman, I would just like to go and pass that out. I'm also going to be handing a copy to Mr. McVeigh as well.
Go ahead.
Like I said, Mr. Chair, Mr. Vice Chair, if the board wants to go and hear Mr. McVeigh in terms of an opening statement, if he so wishes to go and give one, I'll let him give that opportunity at this time, and then I'll proceed with staff.
If I might, I'll defer my opening until Mr. Herman has had opportunity to present his evidence, and I'll do so at that time.
Okay, so I'd like to first call Mr. Derek May for the city's code enforcement officer. Yeah.
You swear to tell the truth, the whole truth, and nothing but the truth for the purposes of this proceeding. So, yeah. Thank you. Would you state your name and position for the record, please?
My name is Derek May, I'm the code enforcement officer.
Mr. Mayor, I'm just going to go ahead and hand you the staff agenda packet that I'll be referring to, and I'll try my best, members of the board, to sort of point to the exhibits that I'll be referring to, as well as the page numbers, to so that you guys can follow along if need be. So, Mr. May, being the city's code enforcement officer, what are some of your duties and responsibilities as it
as it pertains to this case or the this case?
My job is to locate and find or take in any complaints from the city for any code enforcement violations. There needs to be one to the city.
And when did you first get involved with I guess, the beginning of this fence encroachment that we're here before today with the appeal? When did it first become, be brought to your attention? I know several years ago. And just sort of explain a little bit of background of how you got involved.
So it was brought to my attention by the town in November of 23. And then we sent a initial notice of violation January 24.
And looking on page 7 of the staff report that I just handed to you, it does state that there was a site visit conducted by you sometime in October 13th, 2023. Is that accurate?
Yes, that's it.
And these photographs showing the 416 East Bay Street property, were those taken by you?
Yes.
And are those photographs a fair and accurate representation of the appellant's home at 416 East Bay Street, including the fence encroachment that's subject to this violation?
Yes.
And then,
Mr. Bank, will you show us which photographs you're looking
Just the same photographs that you had on the screen just a few minutes ago.
yeah, page 7. Yes, page 7. Okay, so you conducted your investigation, you took those site photos, and then you mentioned that in January of 2024, what did you issue any notice of violations at that time to the Russells?
Yes, the first one is the courtesy / notice of violation, just letting them know that they're in violation, and that went out, looks like January 11th, 24.
And just so everybody's on the same page, on page 22 of the staff report, looking at the city's exhibit E, is that the notice of violation that was first sent to the property owners?
Yes, that's correct.
And is this a true and accurate copy of the notice of violation that you sent to the property owners on January 11th?
It is.
And at the time that you issued this notice of violation, I'm going to turn back to staff report, page 19, exhibit E1. Is this the right-of-way ordinance that the appellants were in violation of? Or in other words, was this ordinance in effect at the time the notice of violation was issued?
Yes, it was.
And if you turn the page to page 20, exhibit D2, actually, excuse me, page 21, the highlighted section there, it's got analogous provision in the city's unified development ordinance that speaks to encroachments. Is that correct?
Yes.
And could you just read into the record for me, section 3.17D, landscaping on public property for the board?
Yes, it shall be unlawful for any person to place or cause to be placed on any public street, road, alley, sidewalk, or other public right of way within the city. Any wall, fence, gate, brick, stone, wood, rock, vegetation, or other structural material or substance above the horizontal plane of the existing ground.
Okay, so given what you just read in terms of the city's UDO and looking back on page 2022 or page 22, exhibit E, the first notice of violation, you noted it was a zoning violation. Is that correct?
Correct.
So that means that they were in violation of UDO section 3.17D.
Yes.
Okay. And presumably you could have also written in that notice of violation, the code section, that 16-8, that was also in effect at the time, which is essentially this analogous language in terms of encroachments in the right of way.
Yes.
So although it's not entirely unique, we have, I guess, ordinances that address encroachments in the right of way, both in the UDO and city code. That's right. And those are the same that exist today. Is that right?
Yes.
It also states in the notice of violation letter that you gave 12 days for the property owners to correct the violation.
Yes.
Is there a set amount of time in either the code or the UDO that specifies how much time needs to be given for the property owners to remediate or correct a violation, whether it's a UDO violation or a code violation?
There is.
Which section is that?
I'm sorry.
Which section? Well, specifically, what's the?
Oh, no, I thought you was asking. Oh, never mind. I'm sorry.
So there's no specific time. So it's upon essentially your discretion as code enforcement officer about how much time to go and give them.
Yes, we typically give anywhere from 10 to 15 days.
Okay, thank you. That's helpful. So you issued the first notice violation letter on January 11th, 2024. What happened after that?
Didn't have any contact with the property owners. So we, going to schedule a notice of hearing.
Now explain to me about the notice of hearing, just for any typical standard UDO violation or code violation, with the exception of the minimum housing code. Is a notice of hearing required for notice of hearing, meaning a hearing, which you can speak to more, not a quasi judicial hearing in the sense in front of a board of adjustment, but a hearing in front of you? Is there any sort of requirement for that?
Not necessarily for zoning.
Okay.
Yes.
So the reason, I guess, being that you give them a chance to have this notice of hearing is for what? Just more due process given to potential violators?
It's to hopefully make contact and come in, and come to some type of understanding of why it's there. If there anything that the town can do to help, or things like that. It's an extra step that we tend to take just to show that we're trying to cooperate and do as much as we can.
Sure. So above and beyond what's otherwise required in the UDO or the code or by statute for that matter.
Yes.
And presumably it's a time where you can sort of have a face-to-face to see if things can be worked out without having to go the step further of whether that's a second notice of violation or civil penalties and that type of thing. Is that right? And you, as a code enforcement officer, you have the discretion on when and what stage or even if to go and issue civil penalties to violators. Is that right?
Yes.
Okay, so looking at page 23, Exhibit F, you stated that you sent the notice of hearing letter to the property owners on March 7th, 2024.
Yes.
And this letter that you sent as an Exhibit F, that's a true and accurate copy of the first notice of hearing letter that you sent to the property owners.
It is.
And then, so after you sent that letter, then what happened?
After we sent that letter, we was asked to somewhat place the property on hold and try to issue another notice of hearing and give additional time.
Okay, because I guess that time frame just for that date just didn't work.
Correct.
Okay, so then after that, you turn the page, so page 24 of the staff report, Exhibit G. You then issued another notice of hearing letter.
I did.
And that was for, let's see, May 3rd, 2024.
Yes.
And this notice of hearing letter, I guess the second one, that was sent on April 23rd, 2024. That's a true and accurate copy of the letter that you sent them.
It is.
Okay, so after you sent this letter on April 23rd, 2024, what transpired? Would the hearing get conducted with you and the property owners, or what happened thereafter?
The hearing was conducted. The property owners did not show up for the hearing, but their attorney did.
Okay, and I believe Mr. McVeigh would agree with me. It wasn't Mr. McVeigh, but it was somebody else, presumably either with this firm, somebody else. Okay. And then after that hearing was conducted, what happened?
We sent out what's called a finding of facts.
Okay, and is that the next page on page 25, City's Exhibit H?
It is.
And is that a true and accurate copy of the findings of fact that you sent the property owners on June 25th, 2024?
It is.
Okay, and what were your conclusions after the hearing that was conducted that's reflected in this letter?
I was asking you, I'm sorry.
Yeah, so what was the conclusions that was reached after the hearing that's reflected in this order? Were they still in violation?
Yeah, they were still in violation. Yes.
Okay, and that would be, section 3.17 something.
And they were given an additional 10 days from the final letter.
Okay. Okay, so what happened after the findings of fact was sent to the property owners, I guess, on June 25th, 2024? Did you have any further discussion with the property owners after that?
Yeah, I did have a phone call from one of the property owners, very pleasant conversation, mentioned, that the reason why they still had the fence there was due to the construction continuing to be going on with the house, and they really wanted some sort of protection to keep things from being stolen off the property. We did come to an agreement that we would extend the time out to August 15th. And that was a 24th, and that was agreed upon by the property owner and myself.
Okay, and did the property owner, specifically Ms. Denise Russell, did she go and send an email to you all, setting forth sort of this agreement to go and extend? Did she send an email to you all to that?
She did.
And is that reflected on staff's report, page 27, exhibit I? Is that email?
Yes.
Right. And in that email, Ms. Russell states, after speaking with Derek May at Alliance Code Enforcement, I have received confirmation that we do not need to proceed with the fence removal until we have received the certificate of occupancy. That seems to reflect exactly what you said in terms of y'all's conversation. Is that right?
Yes, it was agreed that they would have that before the August 15th date.
Okay. And then it goes on to say, I understand that Derek is currently on vacation, took the time to return my call and extend a big thank you. Based on the information, there is no immediate need to take any further steps regarding the fence removal at this time. And I'll keep you updated on developments regarding the CO and the subsequent fence removal process. So it sounds to me that they were in agreement that they were going to go and remove the fence at least at some point after they go and receive the certificate of occupancy. Is that right?
Yeah.
Okay, so that happened in June, latter part of June 2024. What happened after that? Did any other letters get issued to the property owners? What was sort of the understanding, at that time, given that the aldermen were currently in the process of at least addressing possible amendments to both the code and the UDO in regards to the right-of-way encroachment ordinance?
Well, on August 16th, I turned this property over to the town.
Okay.
That the town had authority for abatement. That's the last I've heard from the property owners or anything since then.
Okay, gotcha. And then on December 12th, 2024, the alderman ended up passing an amendment to the Code of Ordinances, specifically section 16-8 and 16-10. Is that correct?
Yes.
And those amendments are reflected on pages 29 and 31 of the staff report. Otherwise, it's city's exhibit J. And then Ms. Meehan already spoke to this briefly in her staff report, but was there a specific direction as part of that motion in terms of what the city was going to do about open cases in terms of violations of the right-of-way ordinance?
Yes, the cases that were open prior to this, we were to just follow along with our normal due process.
Okay, and so in other words, any new code enforcement cases would be given a 6-month grace period, but currently open cases prior to that amendment, those would not be entitled to the 6-month grace period. Is that correct? So then subsequently, after that ordinance was passed, did you and Ms. Meehan issue a final notice of violation that's subject to this appeal?
That's not through me, that's with the other code enforcement.
Well, it does, if you turn to Exhibit L on page 36 and 37, it has your signature there along with Ms. Meehan.
Yes, I recollect now. Yes. I remember this, yes.
And so I guess presumably that was because you were earlier involved in this matter, and that's why, again, this notice of violation is sent off. But yes, correct. This is violation of not only the current code that had been amended December that exists today, but also the UDO violation in or UDO provision in section 3.17.
Yes.
And you said that 416 East Bay Street was one open code enforcement case that existed prior to December 12th, 2024. Were there any other open code enforcement cases, whether the city conducted that you conducted?
Yes, the neighboring property, just one lot up from, 2 lots up from this particular property, 410 East Bay Street was also in violation prior to this.
And what's the, I mean, obviously it was an encroachment in the right of way, but what was the encroachment for 10 East Bay Street?
It is a white picket fence that's in this portion of the right of way.
Okay, and so they were also not afforded the 6-month grace period as far as. Correct. Sorry.
Let me ask a question.
Actually, I'm done in terms of my direct on Mr. Mabe. I might have some follow-up on redirect, but feel free.
Any questions?
What is the status of the 410?
410, they have a hearing coming up next month.
Okay. So it's the same enforcement violations that 416 has.
Yes, yes, I actually had contact with the property owner there as well. We mentioned what was going on, and we come to some sort of the same thing. He mentioned that I guess he needed to actually just remove it, and I explained to him, yes, he needed to remove it due to the ordinance. And
Does the historic overlay, district overlay cover this area?
That would be a question.
Is that taken into consideration during this?
That is not, at the time, the Historic Preservation Commission was working on the historic district overlay. It is currently not adopted, but this property is not within that.
It's not.
It is not
Okay.
in the proposal.
Anything else for Mr. May from the board right now? Mr. McVeigh?
Mr. Vice Chair, thank you.
Just state your name.
Sure. My name is Andy McVeigh. I'm with Murchison, Taylor and Gibson in Wilmington, and I represent the property owners, Howard and East Russell. I have just a few questions for Mr. May at this time. Mr. May, the word that we have not talked about in this hearing up to this point is parking. Are you familiar as to why that might be an issue in this matter?
I've heard some things about the parking issue. I'm not 100% familiar with everything that's going on with that.
Okay, just to get our bearings of the location of this property, and if the clerk might put up the slide that we just had. I'm sorry, who was running the slide?
I got you.
Thank you, and I apologize to the clerk. So, am I correct to understand that the property sits at the intersection of the 1 block long Kingsley Park and, Kingsley Drive and East Bay Street?
Yes.
Okay. And you're aware that Kingsley Park it's a small park with a couple of porch swings, and there is a walkway or boardwalk to a seating area of some sort. Is that right? There's no dock there. It's a small neighborhood pocket park that happens to be on the Intracoastal Waterway. That be a fair description? Okay. And you're also aware that at Kingsley Drive and East Bay, there are 2 handicap spaces on one side of the street. Isn't that correct?
Yes, there is a small parking area right across, yes.
Right, and on the other side of the street, so we're talking about catty corner to the park and just across the street from our client's property, there is a gravel area for parking, isn't that correct?
Yes,
In fact, there were bollards at that parking lot, isn't that correct?
I'm not sure.
Okay, so you're not aware that Ms. Therian or somebody acting in Ms. Therian's direction had those bollards removed and then publicly stated that there was inadequate parking for Kingsley Park?
I don't know anything about that.
Okay. Are you aware that Ms. Therian had submitted to our law firm a drawing of parking spaces that were to be put in the right of way immediately in front of the property that's at issue in this matter?
I don't know.
Okay, so you're not aware of any of those discussions? Okay, but you are aware that we made a public records request, is that right?
Yes,
We wanted to know what, y'all are talking about how you've gone after these other 88 people. So we submitted a public records request, isn't that right?
I believe you did.
Okay, and referring your attention to the materials, if I might have, if you're able to do this, are you able to put page 55 of the staff presentation on the screen?
Yes, can you just a moment, let me get the time to download it?
I'm sorry, no, I'm not going to have you get all that trouble. I appreciate it. I thought that this was actually from the packet. If I may, I'll just show Mr. May. So at page 55, you have it in front of you. We asked, this is back on April the 17th, when we make our appeal here as it relates to this matter. And then we go on, and on the third page of the letter, we say, in accordance with North Carolina General Statute, section 132-6, on behalf of Mr. and Mrs. Russell, we respectfully request that within 14 days of the date of this letter, the city afford us the right to inspect, examine, and obtain copies of all public records within the city's care, custody, and control within the following categories. You see that we first asked for all documents and communications relating in any manner to parking for Kingsley Park. If you've indicated you really don't know anything about that. We asked for all final notices sent to City of Southport residential property owners which relate in any manner to the removal or threatened removal of encroachment from the city's right of way. And then we ask in subsection 3, for all other documents pertaining to City of Southport residential property owners which relate in any manner to the city's efforts to enforce the new UDO in regard to encroachments within the city's right-of-way, including without limitation in regard to, and then we list several property addresses. Isn't that correct?
I see that here.
Okay, and your office endeavored to produce all documents that would be responsive to these requests. Isn't that correct?
Not my office, no.
Okay, who would have been involved in preparing or responding to the requests?
I do not know. I do not want that department.
That's my
Okay,
address.
so you would not have had occasion to produce documents in response to this public records request?
I was not directly contacted for this.
Okay, that would be Ms. Meehan's department. So if supposing that the record is that there are no courtesy letters that are produced to these other 88 property owners who you all claim that you reached out to bring them into compliance, that would be a question I should ask Ms. Meehan in a moment, why she didn't comply with this public records request.
I couldn't answer that either.
Okay, all right, okay. All right. I know the smart Ms. Meehan, we'll talk in a moment. I don't have any further questions. Thank you, I appreciate it.
Chairman, I just have one follow-up question. Maybe real quick, Board Member Ross asked you a question regarding sort of the status and update on the 410 East Bay Street open code enforcement case. You stated that there's a hearing currently scheduled. Now, just to clarify, is that a sort of notice of hearing that you sent, or like the appellants in this case, where you go and meet with the property owners, or is that a Board of Adjustment hearing?
It is a hearing where I meet with property owners.
Okay, and then so presumably there's more steps to be done after that. to get to the venue that we're at here today.
Yes, the original notice of hearing was sent May 22nd. From my understanding, I was contacted by the attorneys, stating that, they were on vacation and did not receive it. So we then went again and gave them additional time and set a new hearing.
All right, thank you, Mr. Smith.
Yes.
So you'd like to call Ms. Meehan? Again, Ms. Meehan, I'm just going to hand you the staff report. They're on reference. Okay, Mr. Meehan, you've already done your introduction. Could you, again, just sort of explain your duties as planning director, video administrator to the board that's relevant to this case?
Yes, so as planning director, I work with the code enforcement officers to ensure that they are following the procedures that are required by law to take violations from their notice to the hearings and final facts. And also I'm a video administrator, so I make the final determinations of policy for the video. Unified Development Ordinance.
And you're obviously familiar with the right-of-way violation that's issued with this appeal.
Yes.
And when did you first become aware of this? Have you been employed as being part of the planning department since this all came about?
Yes.
Okay. And
May I make a caveat on that? I believe that there were some violations or talk of this property prior to my employment, but with the most recent cases before us, that yes, I was employed.
okay. And then in your sort of timeline on page 8, I guess at the time, this was your boss, Mr. Travis Henley, Development Service Director at the time in 2023. This was added to the staff report, sort of for what purpose? To show that this property had a history of fence encroachment?
That's correct. And it was the first time it was really brought up to our staff at the time. Excuse me, that was the new planning staff. So Travis and I came on together in October of 22. So that was the very first time this came with us as the planning staff for the city.
Okay. And if you would turn to page 2 of the staff report, there is the survey that's delineated, I think it's dated September 10th, 2024. It's also Exhibit A on page 13. So when was this given to the city and for what purpose?
This was provided to the city after their home had been completed. And in order to receive a certificate of occupancy, they must provide a final as-built survey.
Okay. So if you look at it, whether it's on page 13 or page 2, you clearly show in red their property line. Is that right?
That's correct.
And then it also shows too where the right of way begins, I guess I'll call it on the south side. And then where their fence is located, almost directly into East Bay Street. Is that right?
Correct.
I mean, would you consider that to be a minor encroachment, or is that pretty substantial?
That's pretty substantial.
Yeah, so if you look at going back to I guess taking a look at pages 3 and 4 of the staff report, I mean, you have aerial views from the Brunswick County GIS 2019. Is there any fence located there?
There is not.
And then subsequently, an aerial view of 2021, there's now a fence according to that aerial view, correct?
Yes.
And it almost looks like, with that fence being built, it almost doubles the size of the appellant's property, wouldn't you say?
Yes.
And according to Exhibit B on page 14, I'll just note, this board can go and take judicial notice of this deed because it's in the public registry. But this is the deed that was conveyed to the property owner subject to this appeal. Is that right?
Yes.
And then according to said deed, if you look at page 17, it actually references map book 19, page 442.
Yes.
And then if you, again, turn to the next page on page 18, city's exhibit C, that's a plat map, or I even call it a certified survey map that clearly shows the property and the property line, is that right?
Yes.
And also clearly shows the East Bay Street right of way, where that begins and where the property line begins, is that correct?
Yes.
So obviously, the property owners were on notice of where their property line was, is that right?
Yes.
But they built the fence within the city right of way anyway, right?
Yes.
So I'm not gonna go and be redundant, going over some of the other exhibits that you have in the staff report. I do want you to explain this a little bit more in detail to the board, but you know, when did sort of the, what I would call the right of way amendment discussion start happening, with the alderman? To your recollection?
The very beginning would be, I would say, probably early 24, so winter of 2024.
Winter of 2024. Okay, so that's almost a full year from the time of these. Off the top of your head, how many discussions, put aside the public hearing portion of it, how many discussions did the alderman have at a public meeting regarding the right of way ordinance?
I can't give you an exact number, but I know it was in multiple instances.
More than 2 or 3
More than
times?
2 or 3.
And so that went sort of all that time until January 2024, until it was adopted in December 12.
Yeah.
And so, you know, there was discussions, you know, according to Mr. Mage's testimony, as well as Exhibit I, you know, Ms. Denise Russell, one of the appellants, you know, she sort of, you know, spoke to that they're going to go and remove the fence after the home was constructed, after they got their CO. And, you know, Mr. Mage said his involvement to some degree sort of ceased around that time in mid-August. So was there a reason why the city didn't go and do anything at that time in terms of the initial notice of violation that was issued in January 2024?
Because we knew that the language was being considered for an amendment, so if there was some way to give any relief, that would be, we wanted to wait, see if there was a way to.
And that makes a lot of common sense, right? Because if the ordinance was changed where the fence would no longer be a violation, or they had a provision that they would be grandfathered in, then that notice of violation would be due. Is that right?
Yes.
So on December 12th, 2024, the alderman adopted an ordinance amending chapter 16 of the Code of Ordinances, specifically sections 16-8 and 16-10. Is that right?
Yes.
And looking at pages 29 through 32, that being the city's exhibit J, is that a true and accurate copy of the ordinance that was amended by the Board of Aldermen at that meeting on December 12th, 2024?
Yes.
Okay. And then turning to the next page, exhibit K, pages 33 through 35. These were the signed minutes from that meeting. Is that right?
Correct.
And is this a true and accurate copy of the minutes from that meeting?
Yes.
And if you wouldn't mind reading to the board and into the record, sort of the last highlighted paragraph there where it starts, Alderman Mosteller made a motion.
Alderman Montfeller made a motion to adopt the proposed ordinance with a 6-month grace from enforcement, and any active code enforcement cases started prior to the adoption of this ordinance shall remain in place. Seconded by Alderman Carroll. Motion carried 4-1, with Mayor Pro Tem Kelly voting no.
Okay, I'm not trying to go and beat a dead horse, but you know, this is significant in terms of this appeal, at least what some of the arguments opposing counsel has inferred in some of his letters and the start of that created. So what does that mean in application? So any open code enforcement cases, the city can just go and proceed without the 6-month grace period, is that right?
Yes.
And then can you just explain, let's say I was never issued a notice of violation prior to December 2024. What was the city's process in terms of making those property owners aware of this amendment and how they can go and remediate within this time frame?
They were sent a courtesy letter in late January of 2025 stating the infractions of their property, the encroachments that they may have in the right of way. We discussed the changes to the ordinance. We included the language of the ordinance and the press release that was provided to the public at the time. And just kind of explained everything, giving our contact information so that anyone had questions, we wanted to work with them to bring everyone into compliance.
And so so I believe there are multiple letters that were sent out since
Yes.
January, around the January timeframe, all the way up until now. And how many new right-of-way code enforcement cases started, from that time? How many property owners were affected?
Just the 410 and 416.
Sorry, new cases.
Done. Wait a minute, wait. That came from the courtesy letters? Is that what you're asking?
Yes, that are
Yes.
new code enforcement cases.
So that is 22 now.
Okay, 22 now, and how many began with?
84.
Okay. And I mean, we can all read sort of the amended ordinance. Could you briefly? Yeah, I don't want to get too much in the weeds. What's the difference between section 16-8 that was amended in December of what was in existence previously?
So this new ordinance allows parking services, specifically allows parking services and vegetation that exists at the time of adoption that did not have to be removed if it were encroaching within the right of way. It also allows for the addition of parking spaces within the right of way. That was not necessarily an improved encroachment prior to the changes.
Yeah, and I'm looking at the revised language or the amended language, excuse me. It still has this provision that wasn't changed that shall have, the property owner shall have 72 hours from the date of the notification to remove, and then it says non-permanent installations of said encroachment or condition. So prior to that, though, according to 16-8, property owner was only given, according to the ordinance, only given 3 days to go and be able to remediate the violation. Is that right? I mean, according to this ordinance,
Yes,
right?
that's correct.
And then if they fail to go and do so, it goes on to say the city may promptly remove said obscure encroachment and charge the cost for removal. Is that correct?
Correct.
Now, I'm going to ask another redundant question. Was that ever done to the property owners in this case?
No.
And, pursuant to the UDO and the city code, could the property owners been issued civil penalties for this
Yes.
violation? And have they been issued any civil penalties at any time?
No.
So after this was adopted, let's go back to, what you stated earlier, there's 2 open code enforcement cases. And then eventually the property owners with this appeal were sent a final notice of violation. Is that right?
Yes.
And that is on pages 36 and 37, at least the actual letter with attachments. Otherwise being Exhibit L in the city's staff report. And this is a true and accurate copy of the notice of violation that was sent by both you and Mr. Mead on April 3rd, 2025.
Yes.
And can you just summarize briefly, what the letter states in terms of the violation and what they need to go and remediate?
Yes, so this was just kind of an outline of the process that had been going on, moving back from the history of the case itself. Talked about the update of the city ordinances that had happened previously, and then that the property was still, the encroachment within the right of way was still in violation.
And it's not only just the fence, is that correct?
That's correct.
It's also the landscaping rock, because that would be considered a part of the structure.
Correct.
So that will also have to be remediated. And you also stated that in the letter as well.
Yes.
And then you also stated in this letter that they had 15 days to go and remove it. Is that right?
That's correct.
And again, is there any sort of specified time frame in the code where, well, besides the 72 hours, is there any other sort of provision that specifies like how long?
There is not.
So that's the discretion of you as the planning services director, UDO administrator, as well as Derek's code enforcement officer in terms of how much time to go.
Correct.
Can you explain to the board, if you haven't done so already, about, what's happening now? Well, has a 6-month grace period for the new right-of-way encroachments. Has a 6-month grace period ended,
Yes,
and that ended on June 12th, 2025?
correct.
And so what has happened or is going to happen to those property owners who did not remove the encroachments pursuant to those courtesy letters that were given in multiple times in the month?
Yeah, so on or around June 15th, notices of violations were sent.
Okay. And then those notice of violation letters specify, what needs to be remediated and presumably how long they have to go and do that too, and the right to go and appeal to this board, just like you've done to this case. I have a few questions on redress, but I got no further questions at this time.
Okay.
Thank you, Mr. President. Appreciate it. Ms. Meehan, you've been with the city for how long?
Almost 3 years.
And were you a Southport resident or a resident of Southeastern North Carolina prior to
Yes.
3 years ago?
Yes.
Specifically, you lived in Southport, is that correct?
Yes.
And you were familiar then that the city of Southport has pretty famously not enforced the right of way issue for a number of years, isn't that correct?
I cannot speak to that. When I was not working for the city, honestly, I did not know about right-of-way encroachments in the city.
Okay, you can speak to the fact that there were 80 odd properties who were out of compliance.
Correct.
Is that right? And I made this point a moment ago, that I'll make it again with you. We made a public records request, that's correct? And that appears at page 55 of the materials in the staff presentation that you submitted,
Yes.
isn't that correct?
Correct.
In category 3, we ask for all other documents pertaining to the city of Southport residential property owners which relate in any manner to the city's efforts to enforce the new UDO in regard to encroachments within the city's right of way. Did I read that correctly?
Yes.
Okay, and among your efforts to enforce the new UDO, you sent out courtesy letters to
That's
these
correct.
folks, is that correct? And you produced none of those courtesy letters in response to our public records request.
That is, I did not know that. We did share our folders with all of the courtesy letters and the Excel sheets with all of the properties with the city clerk that I was aware that it was sent to you.
And the city clerk, I'll offer that we have not seen those documents before. If the city clerk can refer me to an email and I'm overlooking it, I'm happy to revisit my.
I don't know if it was an email. I did share a folder with you.
I swear you if you're gonna testify.
Okay.
Do you want to go in this direction right now? Or do you want to continue with your,
But I should finish with Ms. Meehan and then.
okay.
If you wouldn't know that those documents were included in the same file with the other documents.
That's correct.
Okay, fair enough. Thank you for that. In any event, what we know is that our folks were cited for not being in compliance pursuant to an ordinance that was enacted in December. Is that right?
The original violation was for a ordinance that was in effect prior to December.
An ordinance that was, so in other words, your position on this would be that our folks were out of compliance with the prior existing ordinance.
Yeah.
Is that right?
Yeah.
And that what happened in December of 2024 was wholly unnecessary. Isn't that correct?
No.
Well, in December of 2024, if I'm understanding correctly, from a compliance standpoint, what you did, you actually carved out a couple of things that would otherwise have been
Correct.
illegal under the prior ordinance that the city wasn't enforcing. Is that
Correct.
right?
Yes, sir.
And as far as you know, the city was not enforcing this ordinance. Isn't that correct?
That's correct.
Okay, all right. So there was one other compliance case that was pending at the time of this ordinance being enacted.
Correct.
Okay, and I believe you indicated that you presented the ordinance for consideration. Is that correct?
Yes.
Okay, turning your attention to the staff presentation for just a moment. Specifically, if I might refer your attention to page 34 and page 35, Exhibit K says down at the bottom of this agenda, or excuse me, these minutes. First of all, let's confirm that what we're looking at in Exhibit K is the Board of Aldermen December 12, 2024 meeting minutes. Is that right?
That's correct.
It says right of way ordinance update, Planning Services Director Maureen Meehan presented the following. And this was the update to section 16-8 through section 16-11 of the UDF. Is that right?
Yes.
Okay.
No, wait, no. This was city code of ordinances. Not.
I'm sorry, I misspoke. Okay, so I had that wrong. So the city code of ordinances, which you would say is different from the UDF.
Yes.
Okay, all right. So would you read for me what it says underneath the graphic, below the graphic?
The board discussed the proposed ordinance and asked a question of Director Meehan.
And then then it goes on and it says, Mayor Alt stated, and it quotes, I'm categorically against this action. I see no reason to incur the wrath of an untold number of citizens for no immediate need. We have the right to go in. We have the right to rip the right of way up if we want to. I see no reason to go through this because we're going to do nothing except have hootenanny going on for months to come. And we have so many issues in front of us that are more, and then there's an illegible word, is that correct?
Yes.
And more important than to get bogged down in this action, I'm categorically against it. Did I read that correctly?
Yes.
And then it's Ms. Mosteller, Alderman Mosteller, who makes a motion to adopt the proposed ordinance with a 6-month grace period from enforcement and any active code enforcement cases. It started prior to the adoption of this ordinance shall remain in place, and that gets seconded by Alderman Carroll.
Correct.
Are you aware that Alderman Carroll is a real estate broker, real estate agent in North Carolina?
Yes.
Are you aware that he represented a client and that reached out to my client to see whether he had any interest in selling the property located on Bay Street?
No.
Okay. Are you aware that Ms. Mosteller led the charge in terms of increasing parking for this particular park?
I know there were discussions. I don't know who made the official charge, if you will.
Okay, all right. Were the Board of Aldermen aware of the compliance cases that were pending in December of 2024?
As far as I'm aware, yes.
Okay, they were not walled off from the fact that the Russells were being cited here, is that correct?
That's
They were aware of that.
Yes.
Ms. Mosteller was aware of it, and Mr. Carroll was aware of it, is that correct?
I'm speaking for them, so I can't say yes or no.
As-
but I
as
mean,
far as
I know, yes.
Okay,
Yes.
all right. So with respect to the ordinance, were you approached by anyone on the Board of Aldermen, you or your department, were you approached by anyone on the Board of Aldermen about the necessity of the ordinance?
The necessity, no, it was more of a, this exists. How can we update it to make it usable?
And who approached you about that?
Honestly, it was brought down by the city manager to me, so I don't know who.
Fair,
That's who I, report to.
fair enough. Okay, all right. Thank you. I don't have anything further.
Yeah, to be read.
Very quick. Now, it came out a little bit on the direct, but the whole right of way encroachment amendment, that wasn't just brought up and adopted by the board at one meeting, was it?
No.
The board of Aldermen, rather, they've struggled in terms of deciding on what exactly they wanted to go and do, regardless of the actual language of the code, but whether they wanted to amend the ordinance or not. Is that right?
That's correct.
There were many public meetings, right? Presentations by staff,
Yes.
over that, like you said, that sort of year timeline. At any time, whether it was the actual public hearing or public meetings when this was brought up? At any time, did the Russells ever submit comments to the board as far as you're aware?
Not that I.
Did they speak at all during public comment or at the public hearing at any of this? So they were given the opportunity, just like everybody else, to go and opine on that. Is that correct?
Correct.
Or at least to give their comments on it.
Yes.
That's all I think.
Ma'am, I'm sorry, Mr.
Commissioner McVeigh, you have anything further on that?
Thank you, Mr. Vice Chair. I appreciate it. Just to clarify, your role with respect to the public records request, you produce certain documents, the city clerk or the deputy city clerk, and and she would be the appropriate person to speak to what happened from there. Is that correct?
Yes.
And then, with respect to the property that we're talking about, are you familiar with it physically?
416, yes,
You've actually been out there, you've seen the
Yes.
property.
yes.
In terms of, if there were a parking lot in the right of way in front of the house,
I'm just saying respectfully, I'm going to do it one time and respectfully object to anything about parking and what's going to happen in the right of way.
it's sort of a theory of the case that your client is trying to take this right of way and turn it into parking to render our property completely valueless.
I'm objecting for the record, okay? And
Fair enough.
Your objection is noted.
Okay.
Please continue.
Thank you.
Please keep it under focused as much as possible on the issues.
This is absolutely an issue, Mr. Vice Chair. Make no mistake that parking is an issue in this case. It predominates this case. This is all about trying to devalue my client's property. So to be clear about the location of this property, if there were a parking lot within the right of way, that would require people to back out onto East Bay Street. Isn't that correct?
I have not, of the sketches that were drawn, yes, they were.
And you've seen those sketches, is that correct?
I've seen the sketch, yes.
And what context were you provided these sketches?
As informational purposes only, I was not included in any of this discussions at the time. My director at the time was part of all of those discussions.
Okay, and your director made you aware that these discussions were taking place about turning my client's right-of-way area or the city of Southport's right-of-way area in front of our client's property into parking, is that correct?
Yes,
Okay. When were you made aware of that?
I don't know the exact date. It would have been 2020. I mean, I really don't know. And that's how removed I was from it.
Do you recall whether it was before or after December of 2024 and the enactment of the new ordinance?
It was prior to that, yes.
Okay, you were aware of that?
Yes.
At the time that somebody was encouraging this ordinance to move along? Is that right?
That there was discussions about the ordinance, yes.
Okay, and who was pushing the ordinance along?
I do not know.
Okay. How did you become aware that the ordinance was a concern?
They were having public meetings, Alderman Workhoff. There were discussions regularly with the Board of Aldermen on their agendas, on their regular agendas.
And then how did it translate from a discussion item at Board of Aldermen agenda or public meetings agendas to your work, Ms. Meehan?
The ordinance itself,
Yes, how did we get from the aldermen are having discussion about this to
yes.
we're going to propose an amendment?
So the Alderman requested that staff prepare language to bring forward after the discussions I've been having for many months.
Okay,
Yes.
all right, thank you very much, I appreciate it. Thank you, Mr. Vice Chair.
I just think it's somewhat relevant to the whole timeline. Ms. Meehan, we have current, obviously, amended code provision, right?
Yes.
Well, is there something that's been in the works in terms of UDO update, and what's the status of that?
There was.
For the board's knowledge.
There were some changes. They're moving forward for the UDO, but there were some changes being made to the ordinance itself. So they were put on hold to make sure that the finalized ordinance changes would the UDO would be consistent with those.
Okay. So those haven't been formally adopted by the alderman as of yet, right?
No.
Okay. And however, with that being said, the April 3rd, 2025 notice of violation is subject to this appeal. They are not only in violation of the new amended, updated sections of the code, specifically section 16-8,
Yes.
but they're also in violation of what's on the books today in the UDO, and that's section 3.17B.
Yes.
Mr. Bay, any follow-up to that?
No, I certainly thought you were honored. It's reflected, Mr. Vice Chair. I appreciate it. I don't have any follow-up. Thank you.
Mr. Herman, do either of y'all have anything further from Ms. Neon right now? Okay. I think we've been at this for about an hour and a half. I'd like to recess for a very quick 5 minutes break for any bio needs or anybody needs to stretch their legs. So we'll be adjourned till 6 o'clock.
Bring me some popcorn. I don't know how they look. I'm a butcher too. Sorry.
And we can do that.
Public information.
Wait,
Yeah.
Lifestyle of it all.
Meetings all day, buddy.
You get a Pop-Tart, this is good shit to eat.
One day, when you got feel like.
That's about what you do.
I tried to get lunch.
Everybody buy lunch.
We found a architectural firm.
And say, we have to be your one.
Yeah.
He took a nap.
come back from recess. Has everybody made it back in the room who needs to be here? Mr. McVeigh?
Mr. Vice Chair, members of the board, thank you. I appreciate your time this evening. I know that the Russells do as well. We are asking that the alternative to finding the Russells in violation of the ordinance, that you take one of three actions this evening. First would be to grant them a variance from what I will refer to as the Russell ordinance. It is abundantly clear the circumstances under which this ordinance was enacted were specifically aimed at Howard and East Russell. It was one of the two compliance cases that was at issue at the time of the enactment of the ordinance. Second, if you're not willing to do that, we would ask that you decline to enforce this ordinance until the issues concerning enforcement of the right-of-way ordinance can be further addressed by the Board of Aldermen. We believe the ordinance was enacted imprudently and is being enforced imprudently. And finally, we would otherwise request that you make a finding of fact that the city's enforcement as it pertains to the Russells has been arbitrary and it's been capricious. The evidence in the record is that as it pertains to compliance efforts that were in place before our public records request went out in April of 2025, related to two properties, and that's it. And then a handful of other letters involving other property owners were issued actually after we made our public records request in June of 2025. If the clerk can show us an email stamp where she indicates that she sent to us and we received the courtesy letters, I'll be happy to revisit that issue. We have submitted, and we would ask that this become part of the record, and I believe Mr. Herman has already indicated during his presentation that he has no objection to this. But I would tender as applicant's exhibit 1, the affidavit of Denise B. Russell. I believe that may have been submitted to you by the clerk's office this morning, but in any event, if I might approach and hand up some copies. Just walking through Ms. Russell's affidavit, I think we've already established, but she testifies to this at paragraph 3 of her affidavit. We've established the relative location of the property at issue. Paragraph 2, she testifies they are 416 East Bay Street. They are adjacent to Kingsley Park at 418 East Bay Street. And although there has been this infighting concerning the fencing, or this dispute concerning the fencing, I think the evidence would show, as established by Ms. Russell's affidavit, that Denise and Howard have tried from the very beginning to be good corporate citizens or good citizens. And in fact, they went about elevating their bulkhead by 3 feet when they purchased the property at 416 East Bay Street. And in the process, they, at their own expense, elevated, with the city's permission, the city's bulkhead as well. Just as background, they used to have a house across the street, and then they did what? They acquired the property at 416 East Bay Street and ultimately decided that they would build a home there. So historically, this is a structure, or rather the property, let's try that again. The property at the park and my client's property was home to Karoon Crab Company, which of course has long since been torn down. And to give you further context, and I recognize that a number of you, if not all of you, are probably quite familiar with this location. But the property at East Bay Street in that 400 block, the curbs are nice and high to allow for the flow of stormwater. So the fence that we are talking about as an encroachment sits within several feet of the curbing of the lot. The fence has been there by our client's testimony since 2018. If that fact is in dispute, and perhaps there is a dispute around that fact, I think you can fairly find that it's been there since at least 2019, based on the presentation from the city of Southport. So between the fence and this is a typographical error, which is my fault because of this affidavit, between the fence and the curb are several rocks, which we would say are virtually identical in size and relative location to rocks that are located between the fence and the curbing at 410 East Bay Street, which I might point out is now apparently a compliance case, but was not at the time that this ordinance was enacted. Photograph taken in front of the property is attached as Exhibit A to the affidavit, and I think you will see that the fence that sits in front of that property is nearly identical to the fence that sits in front of our client's property, which is at the left-hand side of the photograph. So, Kingsley Park, I don't think there's any dispute that Kingsley Park is not Riverfront Park. It's a very, very small park. It's comprised of a short boardwalk. It has 2 porch-style swings and a short pier. There are no docking facilities, no public restrooms, no other amenities. And yet, even though that's the case, there are 2 designated spaces for handicapped folks who might use the park. And as the affidavit further establishes, there is plenty of parking there at the intersection. So the park is constructed on land that was donated by the seller for Mr. and Mrs. Russell. And apparently, someone at the city of Southport had the bright idea that the Russells should donate this, as you might imagine, quite expensive lot, city of Southport, in order to expand the park for further use. And our client specifically says that they were approached by Wayne Strickland in May of 2019 about the possibility of donating the waterfront property. And at paragraph 11, she tells you that they were not interested in doing so. And from their perspective, as it's developed in the affidavit, what they believe has followed in the years since is a course of retaliation by the city of Southport. And more particularly, a course of retaliation that is aimed at devaluing their property to the point that it amounts to a taking of their property. So I think all of the evidence in this case, both from our side and from the city side, is that fences are really commonplace in the city of Southport. The fact that you now have 80 encroachment cases that are either at, well, I take that back. I guess there were 80 letters that went out to people. There are 22 open cases currently, but the fact that you would have had to send 80 letters in the first instance is some indication that the city of Southport really has had an ordinance which for the longest time is one that has not been enforced. What that means from our client's perspective, as we talk about this parking issue, is that there will be room for cars to be parked within 5-6 feet of the structure that our clients just built on the property. And as developed in Ms. Russell's affidavit, I mean, there's been testimony around the fact that our clients said, yes, when a certificate of occupancy issues, we'll pull the fence down. And as established by Ms. Russell's affidavit, the facts surrounding that were that she was unaware, they were unaware at that time, that the city of Southport had designs on using this property that sits in front of their house as a parking lot for the car. Also notable, the city of Southport ordinance, or let me try that again. The city of Southport's right-of-way is 45 feet on either side of the midline of a roadway, which is, I think you would appreciate, that's considerably wider than most right-of-ways that you would see throughout other municipalities. So culturally, as I appear to be throwing rocks at the city of Southport as it relates to your enforcement of your ordinance, I'm also mindful that you're faced with a unique set of challenges because your rights of way encompass properties which in other municipalities would not necessarily fall within the right of way. So the plan was they would remove their picket fence upon completion of the home. They didn't know at that time that the city intended to take the area between the fence and what would become the footprint of their home and turn it into a public parking lot. That's discussed in paragraph 13 of her affidavit. On or about February and May of 2024, Alderman Mosteller, who was the liaison to the Parks and Recreation Advisory Board, and as far as I know, she still is, publicly states that the right-of-way immediately in front of the home should be turned into parking for Kingsley Park. Now, I invite you and I encourage you to go out and take a look at Kingsley Park, look at the location of the parking that already exists at the base of Kingsley Drive. But here's what it boils down to. You've already heard that there was open communication between the Board of Aldermen and staff concerning interest in turning this right of way as it relates to our client into a parking lot, where a parking lot already existed for Kingsley Park. And we respectfully submit that there's no legitimate need for the city to make use of the right of way in that area. So there are the two designated parking spaces for handicapped vehicles on one side of Kingsley Drive, and on the other, there is a gravel lot that's made for approximately 10 vehicles. And I would defy you to tell me that you're ever going to have a circumstance where there are going to be more than 10 carloads of people using the property that is Kingsley Park at any given time. So in May of 2024, as my client testifies, according to her testimony, workers acting at the direction of then City Manager Bonnie Therian go out and remove the bollards that designate the spaces in this gravel lot. And then immediately after the bollards were removed, city staff appeared before the alderman, let me try that again, the board of aldermen, and reported that Kingsley Park didn't have parking. Let that sink in. From our client's perspective, what does that look like? We didn't donate our lot to the city of Southport when we were approached about doing that. There's plenty of parking along Kingsley Drive, but no, we need the area that's immediately in front of your house to become parking. In case you're wondering what that might look like, it's depicted in Exhibit V, which is a document that was provided by city staff to our clients and clearly depicts spaces within the right of way. So we've already had discussion concerning the public records request. I'll stand by what's in the record on that point, but it's further discussed in paragraphs 20 and 21. And this leads to our conclusion that the ordinance is being selectively enforced that relates to our client. But as further evidence that we're being singled out for selective enforcement is discussed in paragraph 22 of the affidavit. And this
Just gonna again go ahead and object just once for the record that, whether or not the Russell's property is included within the historic district is completely not relevant or material to this case. In fact, the Board of Aldermen are tasked with that decision. It's a legislative decision. They haven't even made a decision as of today.
and I understand that it's for the record. I was about to respond to the objection, but I understand that Mr. Herman has preserved his objection.
You're welcome to respond to the.
Thank you, Mr. Vice Chair. I'll speak to it in a moment as we talk about this. So I believe it was Ms. Meehan who noted and correctly noted that we are not part of the historic district that was previously brought before the Board of Aldermen at what I believe was its last meeting, if I'm remembering correctly. It was the June or July meeting of the Board of Aldermen. But we were part of the originally proposed historic district, and this is where it gets really interesting. The city of Southport publishes a proposed new historic district that includes our client's property. The city promulgates design standards which say that, among other things, you should locate new parking lots and driveways in the historic district as unobtrusively as possible. In other words, you're not going to have 10 spaces that are going to front the 400 block of East Bay Street. It also says site new parking areas in interior or rear locations where possible. So perhaps the city staff or someone went back and read its own guidelines about what was supposed to be within the historic district. And then suddenly what gets promulgated is a new map of the historic district with one big gaping hole at 416 East Bay Street. The explanation that was provided was that the structure that gave rise to the historical significance of that lot, Karoon Crab Company, had been torn down. Why do we know that not to be true? How can we infer that that is not true? Because Karoon Crab Company straddled the line, and that was the only structure which would have existed on the park property, which remained in the historic district. The only reasonable inference that can be drawn from this, is that the city of Southport realized that it was prejudicing its own position with respect to turning the right of way in front of our client's property into a public parking lot if they included our client's property within the historic district. This on the heels of the enactment of an ordinance, the Russell Ordinance, in December of 2024, which you've already heard based on Ms. Meehan's testimony. She was there, she presented the ordinance. You heard Mayor Alt saying basically that this ordinance is completely unnecessary. We already have the authority to do this. Why are we making this an issue? We have more important things to be doing with our time. And the reason is because they want to turn the area in front of our property into a parking lot. There are other considerations related to the parking issue. And Mr. Vice Chair, I appreciate that the parking issue is not front and center for you to be resolved tonight, whether our client's property should be a parking lot or not. But this is the basis, this is the whole reason why this compliance case started in the first instance. This is why there has been a pattern of selective enforcement against our clients from the beginning. This is the reason why there was no grace period that was implemented as it relates to our client's property. But I just want to call this out. You know, if the city requires our folks to remove their fence and this area becomes a parking lot, there's going to be destruction of the curbing. There will be opportunities for motorists to park within 5 feet of their home. It will allow the property debate to become basically a continuation of the park. And I think if you've ever tried to put your car in reverse on if you were to come out of our client's property and back out onto Bay Street, you'd have to recognize that there is a safety risk associated with turning this property into a parking lot. Additionally, there are environmental issues that are at play. This is an area which has largely been denominated as an area of environmental concern pursuant to North Carolina General Statute, Section 113A-113, and it sits within a floodplain. So, so what we have is the city wants to remove the fence so they can trace. Yeah.
I want to slow you down there. You're straying into the area of offering testimony on a very technical issue. Do you have any documentation on this environmental concern, or?
I do have a map at my office, which I won't offer tonight, but I also have the unrefuted testimony in paragraph 24 of our client's affidavit. I'm not going to tell you that she's an expert, but I don't believe that this is a fact that is in contest or controversy.
No, but I want to remind you that we have to just make our determination based on evidence that's presented to us.
Yes, sir. And what's been presented to you at paragraph 24 is
Statements from your client.
under oath. It's testimony from my client as it relates to the area of environmental concern.
Right.
And I understand. I think this goes to the question of how much weight you're going to give to the testimony as opposed to the admissibility of the testimony. And you can choose to believe it, disbelieve it, whatever the board deems to be appropriate. So ultimately, I have in the Russells 2 good people who really want to get along with the city. They feel like they've been targeted. They are concerned because you walk out the front door and they're thinking that Ms. Mosteller is going to get her wish, and this property is going to become a parking lot that is completely and wholly unnecessary. Why in the world? And I don't expect you to answer this question. Why in the world would the city of Southport remove the bollards from a parking lot that's designated for parking for Kingsley Park, and then have somebody stand up at a public meeting and say that they don't have public parking, or they don't have parking for the park, and therefore they need the area in the right of way? Why in the world would I'm saying you all, that's not fair. Why in the world would your staff do that? That's arbitrary. That's capricious. The fact that you were enforcing this ordinance in order to achieve this end of obtaining parking that you don't need in the first instance, because we would not donate this property to the city of Southport. That's a problem in our thinking. Again, our requests are that you A, grant us a variance, B, send the ordinance back to the city alderman for a further look, for further revisitation of this issue. the city aldermen have left you all with a mess. They've left you with an ordinance that they chose for whatever reason to have you not enforce. Or I think you can say this based on your own personal experiences of driving through the city of Southport for years, if not decades. And now they're telling you to go after this issue. But start with the lot that we want as parking. Start there, and then let's proceed from there. And then finally, if you're not willing to do that, we're going to ask you to make a determination that this is arbitrary, this is capricious, and therefore you're not going to find our clients in violation of the ordinance. I'll be happy to answer any questions, but just so the record is clear, we would ask that what I have marked as our Exhibit 1, applicant's Exhibit 1, the affidavit of Ms. Russell be received into the evidence. I know that I asked some cross-examination questions of staff this evening. I may have been a little bit animated, and I apologize for that. If I offended anyone, it was not my intention. As you can see, we feel very strongly about this issue. We hope, as there are a number of people in the gallery watching, to see what action you all might take with respect to this issue, that you hit pause on this issue and you either grant us variance, find that we're not in violation of the ordinance, at least as it relates to, let me restate that. Either find that we are in compliance with the variance, or that the city is being arbitrary and capricious with respect to its enforcement efforts, or finally, just send it back to the Board of Aldermen and make them clean up the mess that they've created for you. Thank you.
Thank you. Mr. Herman, do you have any follow-up to that?
I guess I'll couple sort of, I guess my opposition to some of the stuff that's in the affidavit as well, including, I'll kind of summarize it all sort of one go, and I'll try to be brief, but let's first start with the affidavit. And I'm not trying to go nitpick, but some of this I think is sloppy testimony. No offense to Mr. McVeigh in terms of his drafting. I think that is fine. He's just going with his client's telling him. First being, it said that the fence has been there since 2018. While that could be a typo or maybe a forgetful fact, let me just point to the board's attention that the deed that was transferred to the property owners, or conveyed rather, was conveyed on December 10th, 2018, as shown on the city's Exhibit B, page 14. So unless they went and constructed something, within 20-something odd days, and more so, the aerial map according to the GIS clearly shows that, there was no fence located in this area nor landscaping rocks at the time that the property owners purchased the property. I mean, it's clear as day what they were trying to go and do. They're trying to go and build a fence and essentially double the size of their lot that clearly encroaches into their right of way. I mean, that is not in dispute whatsoever, and that is the sole issue in this case. Another thing I want to bring to the board's attention, paragraph.
Just to make sure I'm understanding that.
Yeah.
The fence was put in place after they took title.
For every evidence
That's,
yeah.
That, on my little note, that's a crucial item for me. That's highly, I just want to be able to make sure that is like spot on.
Sure. I'll slow down a little bit.
Yeah, sorry, I just wanted to make sure I was understanding you correctly.
Page 4 of the staff report. That's an aerial of GIS 2019. Okay, at the very bottom there. See the right of way?
Okay.
Page 4.
Yeah.
Okay.
Yeah, that's what I was saying.
Turn the page, 2021. No house. No fence. Same location as existing.
Thank you.
Now, if you turn to page 3 of Ms. Russell's affidavit, there's actually 2 paragraph 13s, but I'm noting the first one. So it states that Ms. Russell testifies, we originally planned to remove the picket fence upon completion of construction of our home, and we acknowledged that we told the city that we would do so. Presumably, she is referring to the email that she sent Mr. May and city staff, and that's Exhibit I Staff report. In June, late June of 2024. Okay. That's on page 27 and 28. Now, at the time the statements were made, we were wholly unaware that the city intended to take the area between the fence and what would become the footprint of the home to turn it into a public parking lot. Okay, so she's saying at that time, in latter part of June of 2024, they didn't know about it. But then it goes on to go and say, on or about February and May of 2024, prior to that email, all the stuff about parking and that the city officials made them aware of this, and the former city manager who actually left in latter part of June of 2024 sent them stuff about parking. So which one was it? Did they not know about the parking, or did all of this information come up after the fact? Again, some inconsistencies with some of the stuff in the affidavit. We'll go on to go and reiterate too that this whole conversation about parking and what the city will go and do with their right of way has absolutely nothing to go and do with the sole issue in this case. What the city is going to go and do with their right of way has no bearing on your all's decision of whether staff erred in its decision that this fence and the landscaping rocks are in clear violation of not only the previous ordinance, but this ordinance as well. I'll go on to go and sort of address the three asks that Mr. McVeigh conveyed to you all. One is to grant a variance. That's a creative argument to go and make. However, while this board can go and grant a variance, it's got to go through the proper procedures, which would be applying for a variance, properly noticing the hearing, and you all to go and review that decision under the guidelines set by statute and the UDO for if there's an undue hardship. And even if that were the case, I don't think there's any undue hardship in this case. But that's not for you again. It's appeal of staff decision. The second ask that Mr. McVeigh stated was to decline enforcement until further action by the alderman. I want to go and reiterate again that this board only has the powers of the code enforcement officer and the zoning administrator. You all step in their shoes. They do not, Ms. Meehan and Mr. Mabe, at least at this stage, does not have the authority to all of a sudden not enforce the ordinance. That would be essentially being non-selective enforcement. So you're going to go and cite all these other property owners and not cite the Russells in this case. Again, that's not pursuant to the authority that you all have by statute. And then lastly, his last point, city's decision to enforce is arbitrary and capricious. I think that goes more to this theme that they have brought up a few times regarding selective enforcement. If you all would just turn to my legal memorandum, I kind of want to go and summarize some general premises of the law in regards to that. Now, while the courts have recognized a defense of selective enforcement, I will say there's very little case law where a court has found that as a valid defense. It's essentially a constitutional argument that you are enforcing an ordinance selectively in discriminatory manner in violation of both the federal and state guarantees of equal protection. So that's a constitutional argument. And what the Court of Appeals has stated in North Carolina, it was Dovo v. Zoning Board of Adjustment of the City of Wilmington, not too far away. That court stated that this board, when reviewing an appeal of staff decision, cannot go and consider constitutional arguments. That is strictly for the Superior Court to be able to go and address. So again, it is your all's task by 43 statute that you only go and consider whether staff erred in its decision, and it's either affirm, reverse, or modify the decision being appealed from. But even for the sake of the argument, all the case law out there suggests that it is an extremely high burden to be able to go and have that defense be something that could be entertained by a court or this board. You know, you have to go and show a pattern of conscious and intentional discrimination with an evil eye and unequal hand, not just mere laxity of enforcement. And that comes from a North Carolina Supreme Court case, Grace Baptist Church of Oxford, the city of Oxford. That was from a Supreme Court in 1987. I've also cited some more case law that says that even though there's other property owners that are in violation, just because you cite one person enforcing against him, that doesn't ripen into selective enforcement. And again, how can this decision be arbitrary and capricious from the fact that after the ordinance was amended, 88 property owners were given notice of violations, and then subsequently 22 of those are now being issued forms notice of violations in the exact same manner as the property owners in this case have been. I'll go on to quickly state that sometimes in terms of defense to an enforcement action, there's this equitable remedy called estoppel, where a city or municipality is stopped from enforcing its ordinance due to previous non-enforcement. And just the case law is crystal clear on this fact that just because you have sat and not enforced an ordinance, or even gone to the steps of not only turning an eye, but encouraging the violation, the courts have said that in itself will not go and ripen into an estoppel claim. Holding that a municipality cannot be stopped to enforce a zoning ordinance against a violator by the conduct of its officials, encouraging or permitting such violator to violate such ordinance in times past. That's again from the Supreme Court case, City of Raleigh v. Fisher. So the city is not stopped just from laxity of enforcing in the past to be able to go and bring the notice of violation in this case. And finally, as it deals with right-of-ways and public right-of-ways, there is absolutely no statute of limitations of when you can go and bring an enforcement action. I've cited NC North Carolina General Statute, Section 1-45, which sets forth that premise and highlighted in bold there in my legal memorandum. In case I didn't already go and mention it, parking in terms of the HDC guidelines, whether those have been adopted or not, the district boundaries, and that is all immaterial to the decision before you. So really for all those reasons, we ask that this board uphold city staff's decision, set a time frame of when the appellants need to go and remediate the violation. Whether it's something like 15 days, that's the original notice of violation, something a little bit longer. But I would also ask, at least for you all to go and consider, if you do find and affirm staff decision, what's going to be the city's recourse if they do not go and comply? Will it be issuing civil penalties? Will it be for the city to be able to go and summarily abate the encroachment so they can go and remove it themselves and charge the cost to the property owner? Because again, that is allowable per the current code section 16-8, both the former and the one that's been amended. That's in the books today. So.
Thank you. Mr. McVeigh, anything?
Yes, and thank you, I appreciate it. Just very briefly, with respect to our first ask, while obviously we put forward a position that we believe is sustainable, if you are inclined to make a finding that is adverse to Brussels, I would ask that you suspend the effect of your order specifically to give us opportunity to go through the process of applying for a variance. Thank you.
Mr. McVeigh, Mr. Brady, anyone else that you wish to call this evening? Is there anyone else here who has standing and wishes to make a statement or comment on the proceeding or the matters at hand? Board members, do you all have any questions for anyone who has made presentations this evening?
I just have one brief. No, the approved site plan for this house, where it was cited. Looks like the northwest elevation is right up against the right of the line. Basically, there's 2 feet, 5 inches perhaps of a setback.
Yes.
2-2.
And it just, it looked a bit odd to me that it was allowed to be built so close to the property line.
So when there is a non-conforming lot side with an you can have an existing home prior to that, you can use increased setbacks. And you can also use the setbacks of the average of the homes on the block. And a lot of those are closer to the front setback line.
Thank you.
Is there a final landscaping plan for this home?
I'm sorry, may I speak to that, or does staff wish to speak to that?
Well, you both can.
My understanding is that our clients are prepared to tender a final landscaping plan upon resolution of this issue, but
One
obviously.
is not this.
I'm sorry, sir.
There is not one right now currently.
My understanding, and I've invited staff to jump in if I'm misstating this, but my understanding is that the builder has been in contact with staff concerning a landscaping plan. And I'm afraid to say that they've been told to apply the brakes until such time as these issues are resolved, but I believe that's the status of this matter.
When you're developing a single family home, you're not required to have a landscape plan, a formal landscape plan, other than any tree mitigation that you may have to apply to your property. There were no trees removed on this property. Any landscape plans that he may be speaking of, I believe, were some considerations of allowing a buffer in the right of way itself, which we did not have the ability to allow because we are not allowed to put anything above the horizontal plane previously in the right of way. And we are not allowed to have any new vegetation. There can be some trees if you need to replace a tree that is dying or you needed to remove for the construction of a driveway.
My further understanding is that our clients have spent a substantial sum of money associated with landscaping, but there has been no final plan that has been approved by the city at this time.
Will there be? It sounds like you just said nothing will be approved from.
I have not seen a landscape plan or been approached by anyone for a landscape plan. This probably.
It's not part of the process.
That's correct.
It's not required.
And if it was, yes, I'm just.
Last one,
Yeah.
sorry,
No, it's fine.
was there any note on that site plan regarding the disposition of a fence? I know that item 13 says, yeah, don't worry, we're gonna take care of the fence. I get that. But I would also, I'm just curious if, as an existing condition, oh, by the way, this is coming out, or it's getting moved, or what have you.
I don't know if there were any conditions on the permit itself, but the email that was provided in the staff attachments from former development director Travis Henley, he did notice that it was there and that it needed to be taken care of.
Thank you. All right.
Anything else before we go into discussion? Ray, do you have anything? No.
I don't have anything in clarification.
All right. That being the case, I will close the public hearing on this and we'll go into break. Our decision. Everybody ready to do that? Okay. Hearing's closed. Thoughts? Anybody have an initial observation or ways to tackle this? Question?
Can we get we have a sheet of for findings and facts?
With the,
It's just,
with an appeal, decision, we either affirm, modify, or reverse. There's not beyond that, we do have to base the determination on findings of fact, but we don't have to go through the whole point.
In my view, the decision really would be framed around what Mr. Roberts just mentioned, what you're asked to do, affirm, reverse, modify, to the extent that you can. But then also to consider what's been asked, like Mr. Herman did from the applicant. Granting a variance, delaying any action on it, sending it back to the board of aldermen, or finding no violation, right? And I think it's correct that the variance is not appropriate because there's been no variance application submitted. And therefore, there's not any record to be developed or considered or decided or ruled on as it relates to a variance. Could consider theoretically holding it open to allow them time to file a variance, but that would be something that you could consider further in discussion. The second point about not important, as the board of aldermen could reconsider it further, I don't think that that's proper because this is a matter that this board has jurisdiction over right now. It's not something you can just send back to the board of aldermen. The board of aldermen could not receive it in that sense. To me, the question that's presented among the options that are being presented as to what they are seeking is whether this is arbitrary or capricious enforcement. The tricky thing about that is that they're asking you to find that there's no violation. And I don't think that's the actual focus. It would be not that there's no violation, that you have to make a determination whether it's a violation or not a violation, but you would have to go from there and say, we're not going to enforce or take action, even if there is a violation, because there's some sort of arbitrary or capricious enforcement going on that precludes or should preclude our ability to enforce. And those are issues that Mr. Herman talked about in his memo as to whether this situation would rise to the level of meeting those standards, and they are very high standards, according to the case law. I think the board would consider it, but also it is something to keep in mind too. I think Mr. Herman is right when he says that the code enforcement officer and then the board standing in his shoes for these purposes really isn't in a position to properly at this stage declare that there is no violation, or if there's a violation, we're not going to enforce, because the enforcement of the violation is something that the board would have to proceed with. And if there's to be a remedy for a violation that they would like to challenge on some bases that are outside the scope of what this board can do, that would be a process by which they would appeal it to the courts, and the courts could consider it at that level. But so I think that's just in terms of how you start the thinking, decision-making process. I think that's a general framework from my perspective, considering how to approach it.
Can I go ahead and make a motion to start it that way? I make a motion that this board uphold decision of the zone of the CEO, Chief Enforcement Officer. Based on the fact that there is an admitted clear violation of city ordinance and code, and the fact that the hardened structures are in the right of way. But the ordinance prohibiting hardened structures in the right of way existed before this property was purchased by the current owners and before any fence was erected. What else? Other,
I'll second the motion.
I don't know if there's any other findings of fact that you'd like us to include in it. But, it's not arbitrary and capricious because we've issued, cities issued letters to all known right of way violations. It's like what, 3/4 of them, 2/3 of them have been resolved.
Motion made and seconded. Any other discussion?
We have to have a ready access about having, to how we're going to enforce it in this motion. That's the motion.
You can, I guess we just include that in there.
Right, and add that to your motion.
And I go ahead and say that,
John, before you say it.
Yep.
There's only one thing I want to do include, gentleman from code enforcement. I think there was a discussion that included a time commitment that they tied it to the C of O. I thought I heard that earlier, that, okay, this is.
yeah, they put it in.
Right, so I just want to be careful when you talk about establishing a deadline. Be, in fact, that bubbled up before, and I don't know if we can set that aside and make it some different date, or we have to stay with
Well,
that.
C has been given.
Oh, it has?
Yes.
I did not know, my mistake, I didn't know
C
that.
has been granted. They do that fast.
My bad.
No problem. I'd say 2 weeks. We give them 14 days to remove it.
And if they don't,
That's up to us. That's not.
It said further cures provided in the
Yeah.
ordinance.
And the follow ordinance, the ordinance has provisions in there.
it's just what we said, it's a penalty.
We want to remove it and send it across.
Yeah. I don't think we really need to or necessarily can put that in, because it's already in.
No.
I don't think we need to restate. So,
You want to restate your motion?
I'd love to, but I don't think I can. It's being recorded, why do I have to say it?
What you had so far?
Yeah.
Okay, you made a motion that the board upholds the code enforcement officer's decision based on the fact that there is an admitted clear violation of the city code and hardened structures in the right of way. An ordinance prohibited this before the property was purchased, before the current owners, and before the fence was erected. And then you want to add your,
Well, then I added, it's not capricious or, whatever the other word is.
Arbitrary.
Arbitrary because the city went out and identified 80-some violations, noticed all those violators. And 60-some of them have come into violation. Come into compliance.
That's not ours to-
So there's nothing arbitrary about that.
Everybody's clear on.
And then a 2-week period to have the fence and rocks removed. Clear the violation. 2 weeks.
And then if it's not done, then the city can pursue the remedies that have.
Yes, and
The city will institute what they've got on the book.
yeah,
Right?
exactly.
Period.
You can be generic like that or specify.
I think this city can then undertake the remedies that it has the authority.
that's the ordinance.
All that. Your second.
Second.
Okay. Any further discussion? All in favor, will hold. Start with you.
Aye.
Motion carries.
Mr. Vice Chair, I would renew the request that you suspend and stay the effect of the order until such time as we go about the process of applying for a variance in accordance with the order.
As long as it's been going on.
Do I hear a motion in that regard? Not hearing a motion, we will proceed to the next item on the agenda. All right. Any other business? Or no other business before this evening?
Bye.
Other business before this meeting stands adjourned.